Friends, what should you do if you're an adult child of a U.S. citizen or a green card holder and your parent filed the I-130 petition for you and it was approved? But now what? You're here in America and the petition was approved, but you don't know what steps to take. Should you file for adjustment of status? Should you go back home and be interviewed at the U.S. Embassy? What should you do? That's what we're going to talk about in this video. Before I get into it, I just want to tell you guys thank you for following me. Thank you for watching. Thank you for subscribing. Thank you for being part of this family on Instagram, YouTube, Facebook, wherever you follow me, guys. I just want to tell you thank you. Thank you also for sharing my information with your family and friends. You guys may give my office a call, schedule a consultation to speak with me and talk more about your immigration issue. Now, let's get into it. Let's see, there's the F1 category, which is the adult unmarried child of a U.S. citizen. This impacts the F1 people. Then there's the F2B category, which is the unmarried adult child of a green card holder. And then, friends, there's the F3 category, the married sons and daughters of U.S. citizens. So the issue that we're going to talk about in this immigration video touches on all three of those categories. So if you find yourself in one of those three categories, pay very close attention to this video. Now, if you're here in the United States, the biggest issue is, can you file for adjustment of status? Because you're here, it makes sense to file for adjustment of status. Why not? Well, friends, here's the big problem with that strategy. The biggest issue is what I like to say, this wall. When I'm in consultations, this is what I do. I put up my hand and I say, there's a wall standing in the way between you and the green card. And that wall, my friends, is called unlawful presence. If you're here and you do not have a valid or a lawful status, I should say, you're going to encounter this wall of unlawful presence. It's an inadmissibility issue, and you've got to address it in order to get the green card here in America. And so if you're here and you've been here for years and you don't have a lawful status, you've been accruing unlawful status, as a matter of fact, the government wants to know that you've dealt with this issue first before it allows you to have a green card. And the way to deal with this issue is to ask for forgiveness as a person who's in F1 category, F2B, and F3 category. So how do you ask for forgiveness? Well, it's called the I-601A waiver. It waives the unlawful presence only. And I have some old videos on my channel that touches on how the unlawful presence waiver works. I'm going to put a link to those old videos here. Watch the videos and see whether or not you guys are really eligible for it, because not everyone will be eligible for this waiver. But if you do in fact have a U.S. citizen or a green card holder parent, I must inform you, I do want to tell you that you are eligible on that basis, but it goes much deeper than that, friends. You're going to have to prove that your parent would have suffer extreme hardship if you have to go back to your home country permanently. So the focus of that is really on your parent. And if your parent is doing very well, or if your parent spends half her time here in the US and half her time back home, and she doesn't really need you, she's independent of you, there's really nothing wrong with her, she's healthy, she's happy, she's financially strong, then you're going to have a tougher battle with respect to that waiver. So that's one issue you're going to encounter, this wall called unlawful presence, this inadmissibility problem. So let's set an adjustment of status aside for a moment. The next issue is, well, what can you do if you cannot adjust your status? And friends, I didn't have to do this particular video, right? Because I could have had you just come in and meet with me and I'll answer these questions and we brainstorm about what you can and cannot do. But I just want you to know that I'm doing this video because I want to be helpful to you, because what I'm finding is that people are spending a ton of time trying to prepare to go through adjustment of status under public charge. They're getting so anxious, they're stressed out, they're working on the declaration of self-sufficiency, they're trying to find money to pay legal fees to do adjustment of status now under public charge, and they're going through so much drama and stress when they don't have to, because they're not even eligible to file for adjustment of status in those categories if they have this inadmissibility issue standing in their way. So then the next issue is, well, what can they do? How can they ultimately get through? And what they could ultimately do, friends, is they would ultimately, as I've mentioned, they need to file for the waiver, number one, and then they'll have to go back home and be interviewed at the U.S. Embassy in their home country. And that road to the embassy, friends, needs to be a road that is carefully treaded upon. And why do I say that? I say that because you want to make sure you have a good, clean record, no other issues on your record but this unlawful presence issue that you could address with the waiver, and you get that waiver approved. Then you can continue with consular processing, get your interview scheduled at the embassy, go home, have a wonderful interview, get your immigrant visa, and come right back to the U.S. That's the road that you really want to tread on very carefully if you don't have a clean background. If you have a background maybe back in your country or even here in the U.S., and you have some unresolved issues that will come up during the background investigation part of things, you're going to want to really make sure you carefully address all of those issues before leaving America. Because the last thing you really want to see happen is that you get stuck outside of the country because the embassy finds something else. And what could that something else be? That something else could look something like this. Maybe 10 years ago, you filed a visa application, and on that application, you may have omitted the fact that you have another child in your country. You've just omitted. A lot of people omit. So you omitted. You forget about that, right? 10 years go by, you forget about that. Your parent here in the U.S., somehow you came to the U.S. on a B1, B2 visa, and you've overstayed. Your parent filed for you, submitted the I-130 petition, it gets approved, then you're waiting your turn until your priority date comes up. It comes up and you initiate the visa application process, gets started, and you file the waiver, you get the approval, and then you get your appointment notice. You go back home to the embassy. Let's say Kingston, Jamaica is the embassy where you're going to be interviewed at. You go to the embassy, and the embassy official says, well, how many children do you have? And you say, I have 3. And the embassy official is looking at the file and sees that, well, you omitted someone 10 years ago on this visa application, and that kid was alive at that time. But you forgot all about that. You forgot about it. And so you get on your interview, and the embassy official says, well, on your current visa application, you've noted that you have 3 children, but according to our records, we're showing 4 because one was born January 1st, 1991 or something like that. And you omitted that child, and in fact, you have 4. And so that's how they catch people who do commit fraud and misrepresentation. But if you have not ever committed fraud or misrepresentation, you have nothing to worry about. You don't. Now, if you did commit fraud and misrepresentation, you should have applied for forgiveness before you left America. You should have addressed that misrepresentation issue first through the waiver process. And so, friends, these are issues that are very, very complex, that do come up, that hinders adults from getting through. And so you've got to make sure that you work with a lawyer to address these issues and make sure that your record is well documented on your side. You need to have an understanding of what's in your record so that you can address everything that needs to be addressed. Address it during the waiver process, and then you can feel free to go back to the embassy and be interviewed and get that immigrant visa issued. Now, the last issue that you need to be aware of with respect to all of this is that we currently have a 60-day suspension or ban in place that does impact adult children of U.S. citizens and green card holders. And so what that means is that you're not going to receive an immigrant visa from a U.S. embassy during this time when the suspension is in place. No, you will not. So you've got to think about that, because politically speaking, there's talks on Capitol Hill and from the White House about extending that suspension. And we don't really know yet, as of the filming of today's video, we don't know when that ban will expire. And so you've got to tread carefully here, right? Because you don't want to put yourself in a position where you leave the U.S. for your embassy interview only to find that this ban is still in effect and you cannot come back to America with that immigrant visa quite yet. So those are some of the thoughts I want to leave with you today. You F1 people, F2B people, and F3 category folks. These are complex issues. Do not tackle these issues on your own. Work with us, give us a call. We work with people who are in this very situation, and we are helping these individuals get their waivers approved so that they can in fact go back home and be interviewed at the right time, of course. And so friends, timing is important when you're thinking about leaving the US. Just know that you don't have to rush and leave right away for that embassy interview. You need to work with your lawyer to time things out the proper way so that there is no ban or suspension in place at the time when your appointment comes up. So think about these issues, friends. And again, I didn't have to do a video like this. It's very, very difficult to find a video like this on YouTube or anywhere that really addresses some of the complex issues that people who are in those categories really do face when they're here in the US. Very, very difficult. Now, the last thing I do want to leave with you is this thought. Well, I've heard that, I know other people who get through, right? They were older and their parent filed for them and they were able to adjust their status. Well, I will tell you this, the individuals who are able to adjust their status in those categories, they already have a lawful status in the US from another means, meaning perhaps they have H-1B visa or another visa type like the L-1 visa that is longer than a year or two, right? That gives them enough space and time, and those visas are renewable as well. So while their adjustment of status application is pending, they still have those visas in place that gives them a lawful status here in the US or in any other visa type that they're able to then renew and maintain a lawful status here in the US. So those are some of the cases that you hear about of adults who are petitioned for by their parents who are able to adjust their status in the US. So friends, I hope you found this video helpful. Share it with other people. Comment below, let me know your thoughts, and let me know what other topics you'd like for me to address in upcoming videos. Friends, thanks so much for watching, and I'll see you in the next one. Bye-bye.